First, we'll talk about the application for correction of award, which is governed by Article 33.1 subparagraph A. A party can avail of this within a limited period of 30 days from receipt of the award. And it can only avail of this under the grounds of errors committed which are computational in nature, clerical or typographical, and others of similar nature. Note that this remedy is echoed, but in slightly different language, in Article 36 of the UNCITRAL Arbitration Rules. The permitted corrections are narrow and only for the purpose of addressing unintended errors. It is not supposed to modify the reasoning and findings of the arbitral tribunal. An example of a typographical error is that in the body of the final award, the tribunal speaks of granting a claimant $100 million, but in the dispositive portion, it inadvertently only mentions a grant of $10 million.
Often it's said that closing submissions are better presented in writing than orally. If you're presenting your submission at the hearing, you haven't yet had time to digest necessarily everything that's been done at the hearing, all the evidence that's been provided, and sometimes having some time, not too much time, to cause delay afterwards can really be helpful. Sometimes, or alternatively, notes which summarize the oral arguments or a closing statement may be sent either during the hearing or shortly thereafter, again, to summarize the key points, because it's hard sometimes to distill all of this information when there are hundreds, if not thousands, of documents. Now, at the hearing, the tribunal may ask if the parties have any additional submissions to make, and if there are none, declare the hearings closed. But even though the hearings are closed, the submissions that come after the hearing can still be made, obviously, prior to the award being read.
In the case of organizing a hearing, in practice, this is what happens. First of all, expect your arbitrator to be reasonable but firm. If your arbitrator is unreasonable, that may be cause for that arbitrator to have been doing something wrong or not proceeding with due natural justice. On the other hand, if your arbitrator actually is giving in to everything and anything that the parties want, then you also have some concerns that your arbitrator is actually not being firm enough. In organizing a hearing, your first step would be to hold a preliminary hearing. This is when, soon after an arbitrator is appointed, the tribunal will then call for a preliminary hearing whereby parties will attend, and the idea behind this preliminary hearing is actually to manage the case.